IP, what's your position on IP? I mean, is it complete no protection of IP, something extreme like that, or is there some protection to encourage innovation?
No, we do believe in some protection for IP, but there's a whole heap of reforms and changes. Like as far as copyright's concerned, we'd have a whole heap of fair use exemptions. Now, one of the things we get into is like the right to repair, say. And this is a whole, it is actually bubbling, and I think it's sort of starting to get to the mainstream. But, you know, the cliche is you've got this farmer in Western Australia. They're so damn far from like civilization. They've got this farming equipment. Their harvest season runs a few weeks. And if one of their bits of equipment is out of action and they've got to wait a few weeks for some guy from Perth to travel all the bloody way, oh, okay, we need this spare, all right, I'll order that, that'll be a week away. That sort of makes no sense. And, you know, there is the idea of the right to repair. And this is another thing about individual freedom. There's some people who run repair cafes. They talk about the dignity of risk, okay? And, you know, it is one of those things that I guess a slightly libertarian sense is, you know, cotton wool drawers and that sort of thing. And, you know, my own personal view is, look, companies have a legitimate concern that, you know, you don't mess with their thing, injure yourself and get sued, okay? We do think there needs to be some sort of way of saying, look, I'm going to mess with this. I'm taking the responsibility onto myself. If I injure myself, it's my own problem. But I do think a lot of firms run around saying, oh, we can't let the consumers do blah, 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 because they might hurt themselves. And that's actually an excuse for them to flex their muscles in terms of intellectual property.
Yeah, so John, just for clarity, what do they do that prevents you from repairing it? They void the warranty. They say the warranty is voided if you do any work on it, if you actually open it up.
Well, there's a few things. One is the warranty is voided. The other one is software that basically logs the fact that you've opened the case or tried to tamper with it. And worst case, you have software that basically self-destructs if you meddle with something.
Whoa.
Right? That's you know, that's getting even more serious. I mean, there was a story of, I think Sony put a dodgy thing on CDs that actually put a program in your laptop that stops you from doing further copying of CDs, and that was well, that caused quite a kerfuffle in the IT world. Whether it got to the outside world, I don't know, but there's some dodgy stuff that goes on there. But anyway, so fair use exemptions for copyright, okay, and obviously that sort of spilled into the copyright of bits and pieces, of right to repair rather. And certainly, I think the Australian government does have something that if you sell a car and you stop selling it, you got to keep selling the fit spares for 5 or 10 years. But we also think that once a car is no longer really properly supported, it should be a free-for-all for people to make knockoffs and, you know, run their 3D printers, bananas, whatever. Yeah. So I think there should be thresholds where, okay, till this point, people could claim a bit of copyright and this sort of thing. But beyond this point, come on, let people rip in. But as far as patents go, for sure, our view is a few things. One is that that basically patents should only be used to protect stuff that's actually being bought and sold in the market. And if you go back far enough in our copyright legislation, no, sorry, I should say our patent legislation, but there was a previous thing saying that if you have a patent, you have to serve the market. There was actually an obligation in legislation. In other words, it was saying, if you've got a patent, you should be bloody making stuff and flogging it, right?
Yeah.
And our position is that if you have a patent, then you should be making it. You shouldn't be using that patent defensively and stopping others from doing it. And there is the whole thing of, you know, patent trolls who have a bunch of patents sitting on the shelf, and all they do is run around with a mallet and whack people on the head who try to make that. And to my way, I think that's a complete abuse of what a patent should be. And we also have actual schemes where you actually declare the value of your patent. And if you're not declaring it properly, someone can just put up their hand and buy the patent off you. So you have to value it publicly in a way that sort of is sustainable. And
Yeah.
I suppose there is the whole thing of copyright, that it shouldn't be, you know, death of the author plus 50 years or 70 years, which is ridiculous. Now, the US kept trying to extend the copyright of Mickey Mouse
Yeah.
to keep them. And so that was, to my way, I think, a clear abuse of the patent process. So you've got patent trolls. You've got so-called evergreening of patents, where a medicine is used for one use and then they figure out an alternate use and get an extended patent on it. But it still gets a bit grey as to whether you could use it for the use that's sort of run out of patent. And I suppose a broader thing would be lovely. My vision is that, you know, an arm of the UN farms out grants to the universities for basic research. And if some particular university then comes up with a U-Butte idea, then the free market can get that idea for a nominal license fee and then rip in and sell it. And that's repivoting the whole way corporations relate to medical patents, say. So notice we're not totally against patents for medicine, but, you know, these medical firms, I think there's something like, oh, look, they spend a bucket load on R&D and they spend even more on marketing. You know, to my way, I think that's telling us, look, there's something wrong with this picture.
Yeah.
And there was a story, goes back a good, unfortunately, I'm not up on these things recently, but going back about 10 or 20 years ago, there was a bunch of researchers in the UK that made this variant on interferon, and that actually evaded the then existing patents. And then they hired some Indian chemical firms to crank this stuff out. And it was what you might call an open source pharmaceutical, metaphorically. And those sorts of models, I think, are much better. But then there's the fact that in the US, like mere, you know, clicking on a button, software patents, to my way of thinking, look, this is going into the technical details of patent law, but I know a lot of commentators who said that, like, way back when, 100 years ago in the UK, a patent was something that you basically bribe someone to do good things in the community for the general good of society. In other words, yes, you were making a profit, but it should be articulated that not only were you making a profit, but society as a whole was benefiting. And that was the way the Brits articulated patent law 100 odd years ago. And it's my view that that got morphed into the US, and the US much more was worried about coveting assets. You know, people own this and we've got to protect the people who own it. And then the lawyers got in and defined all these things around it. So the emphasis changed. And along the way, the idea of the inventive step got watered down. And it used to be that was a very strong thing. This had to be really creative. You've done something big here. Yeah. And then that's been diluted in US patent law to think, oh, you've run this algorithm that anyone could have dreamed up. You clicked over here. Oh, yeah, we'll give you a patent for that. And again, going back in patent law, there was, I think, a manufacturer of, goodness me, of airline engines, of engines for aircraft. And they actually came up with this way, you can operate this engine in a certain way and reduce noise, and they wanted to get a patent on it. And the judge at the time said, look, these people piloting these planes are responsible for hundreds of lives, and you want to add to their cognitive load that they can have to actually figure out whether they're licensed to operate this bit of equipment in this way or not, based on how they're licensed. And that particular judge said, you know, go away, that's nonsense. And then, you know, there's obviously the more recent excesses like the EpiPen. Someone was sort of making a gadget to check for COVID, and someone else wanted to do a patent injunction against them. I mean, even if they have a bit of a case, the best that the legal system should do is say, this is something of merit for society. Let's let these people make the COVID equipment, and you can do a court case and extract profits from them after the event if it really is relevant. Yeah. But so there's a whole lot of messiness to do with intellectual property. And what's a few other things I can point out that like with Hollywood, I don't know if you heard the term Hollywood accounting. There was a guy who wrote the novel. Goodness me, what was it called? Forrest Gump, I think it was. And the first movie didn't make a profit, and they wanted to make a sequel. And he's saying, why the hell do you want to make a sequel if the first movie didn't make any money? And so I think there's this moral duplicity where Hollywood gets very resentful about people copying their movies, but has no problem with diddling their creative partner partners on their end of the fence. So there's some dodgy stuff going on in the copyright industry there. And there's various cases of, you know, bands in Australia getting done by overseas copyright claims on music in their tracks. And you know, I think there was the band Men at Work was dragged through the court. So there's a whole lot of dodgy shit going on with intellectual property. What's another story? That I think Mattel had the Barbie doll and they had a copyright on the Barbie doll, and someone wanted to do a book on anorexia that had Barbie in the title, and they said, no, you can't do that. So again, copyright, trademarks, you know, defamation, you had all these things intermix. Sure, you shouldn't be able to sell a knockoff doll and call it Barbie and make money out of it. Okay, maybe. But, you know, protecting your trademark and stopping people from doing derivative creative works. I mean, come on. So anyway, oh yes, okay, there's one more thing I will say, which is I think a bit of a sideline to do with Trump. Now, you might remember Trump was pushing back against the Trans-Pacific Partnership, and he obviously managed to win an election. And it's my suspicion that a lot of people in the Rust Belt saw all of these trade treaties, and what those trade treaties meant was that, you know, overseas countries could sell stuff in the US in exchange for them recognizing US intellectual property laws. And look, let's just say, look, you're the economist, and I'm sure we will agree that on paper, you have international trade and parties benefit and the net wealth is increased. But under the hood, what happened in the US was there was a net transfer of wealth from people who made stuff with their hands to people who owned ideas. And it's my suspicion that that might have been one of the factors in the Rust Belt of people going, hang on, there's all these lovely trade treaties which are supposed to be so beneficial, and we see ourselves losing our jobs.